Today, we're going to be discussing the updates to the EU AI Act, which were made by the Digital Omnibus on AI, which has now been provisionally agreed. The European Parliament has actually voted and agreed on it, but I think the Council still has yet to finalise. Just to say, if you have questions, feel free to enter them in the Q&A box. And if we have time, we'll have a Q&A session at the end. But if not, we will look at all the questions and get back via an email update. So don't worry, you will get your chance to have your questions. So I thought I'd just do a quick revise of the different sort of risk categorization that we have under the EU AI Act. First of all, we have unacceptable levels of risks. Some systems are deemed to carry an unacceptable level of risk, and so they can't be placed onto the market, put into service or used. I'm not proposing to go through those because we're going to concentrate really on high risk today. So high risk systems, you may recall that they are split into two categories. So we have the first category, which is detailed in Annex 1. So these are things which are intended to be used as a safety component of a product or system, or it is the product or system which is covered by union harmonisation legislation and is subject to a third-party conformity assessment before it's being placed onto the market or put in service. So we've got two parts to this. We've got the first part and the second part, part A and B of that annex, and it covers things like machinery, toys, lifts, radio equipment, medical devices, civil aviation. And in the first section, those systems have to comply with the harmonised legislation covering that sector and also the AI Act requirements. And second section, really the concentration is on complying with the harmonisation legislation. That's where there's already sort of very established sort of safety legislation in place there. So then we have the second category of high-risk system, which is standalone high-risk systems. So these are systems that pose a significant risk of harm to health and safety or fundamental rights of persons. And they are split into 8 major areas of risk. So we have biometrics, critical infrastructure, education and vocational training, employment and worker management, access to essential services, law enforcement, migration, asylum and border control, administration of justice, and democratic processes. Just concentrating on just a couple of those. So employment, that's specifically recruitment, decisions affecting the terms of a work-related relationship, allocation of tasks based on individual behaviour, traits and characteristics, and monitoring and evaluating of performance and behaviour of workers. Biometrics, we've got remote identification, and situations where biometrics are intended to be used for categorization according to special category data, sensitive data, and AI systems which are used for emotion recognition. Just concentrated on those a little bit because I know those two are a little more sort of common. Also want to highlight at this point that there is obviously the exemption to the high risk categorization. So you might have a system which would otherwise be a standalone system which is high risk, but it's not considered to be high risk because it falls within this sort of filter that we have to say it's okay, actually you don't need to comply with the obligations. So we've got systems that perform narrow procedural tasks like detecting duplicates, systems that detect decision-making patterns or deviations from prior decision-making patterns of human beings. This is systems which improve on the result of a previously completed human activity, or those where there are sort of preparatory tasks to an assessment. But important to note that these sort of derogations don't apply where there is profiling involved. That's a sort of a hard stop. And just to make it clear, because I know it was sort of in discussion over the course of the iterations of the Digital Omnibus, you will be required to register exempt high risk systems. So that has been retained, that requirement. So what have we got? We've got, and this is in the Digital Omnibus, moving on to that now, we have a new prohibition, which is the ban on the creation of non-consensual intimate content and child sexual abuse content. So it's prohibited to generate or manipulate non-consensual images, audio, video, or similar material, or child sexual abuse material. Now, this is, I think, in large part sort of developed from the Grok scandal, with people managing to remove clothes from pictures of real people. And they are, you might hear them referred to as nudifier apps, which is how they've been referred to sometimes. So this is where it's either the intention is that the system does this, or where it's a reasonably foreseeable and reproducible outcome, and that you don't have those safeguards and technical reasonable and adequate technical safeguards to prevent that from happening. So if you're a provider providing image and video generation, that's something to be aware of. And for deployers, obviously, you wouldn't be allowed to put a system into service. Now that applies from the 2nd of December 2026. So moving on to key dates that have changed under the Digital Omnibus. So first of all, some of the transparency obligations in relation to AI generated content. Now this is sort of the watermarking of AI content, but this only applies to systems which are already on the market before the 2nd of August 2026. So if you're putting a system onto the market which is generating AI content like media and sound and things like that, if you put it on after the 2nd of August, you'll have to comply with those watermarking requirements straight away. Also worth noting that there are wider transparency obligations under Article 50, and it's just that particular watermarking one where there's a delay in the application. So just to notice as well that there's a code of practice has been issued in relation to the transparency obligations that we were just talking about, and it will be accompanied by guidelines on the obligations, which will be forthcoming. So the second sort of major date shifts we're looking at relate to the high-risk obligations. So first of all, we have the high-risk obligations for the standalone AI systems. So those are the ones we were talking about in terms of like biometrics, use of AI in employment and recruitment, critical infrastructure, and things like that. So they are being postponed until the 2nd of December 2027. So in relation to the obligations for embedded systems, so that's Annex 1, they're being moved out even further to the 2nd of August 2028. Now, I just thought I'd just have a very quick canter through what's the high risk obligations. I'm not going to cover them all by any means because we just don't have time today, but looking at sort of the full requirements in terms of, obviously some of the Annex 1 systems only have to comply with their sectoral legislation, but not leaving that aside for the moment. For the ones that do have to comply, for providers, there's sort of a list of requirements which relate to the system itself, and then sort of that quality and risk management system, how you're going to detect and mitigate risk, data and data governance, sort of specific technical documentation that you need to keep, record keeping, transparency and human oversight. So that's just a number of the requirements. As I say, can't go through them all. And the providers have to ensure that their system complies with the set of requirements for the system, and also has another set of requirements, which is sort of indicating your name and registered trademark on the packaging, making sure you have a quality management system in place that meets the requirements of the Act, a certain documentation requirement, which does cross-refer to the technical documentation in some situations, keeping logs, ensuring conformity assessments are carried out where they need to be, and that there are CE markings, demonstrating conformity, correcting non-compliance. So those are the sort of provider requirements. And then looking over to deployers, you need to be ensuring that the systems used in accordance with the instructions, that you assign effective human oversight, and where you have control over it, you need to ensure that the data you input is relevant and sufficiently representative, monitoring the operation of the system and telling the provider if there's any particular risks to health and safety or fundamental rights that they haven't sort of come across so far. Keeping the automatically generated logs, which are produced by the system, informing workers where they're subject to the use of high-risk AI, DPIAs, where we've got personal data involved. There are fundamental rights impact assessments, but these are quite narrow in terms of the cases where they're required. So, for example, the credit worthiness of individuals and looking at sort of risk for health and life insurance as well. And also providing transparency information to affected individuals. And it's also sort of worth saying there are obligations on importers, distributors and suppliers, but I haven't gone into those here. Just to mention here, actually, just there wasn't sort of a particularly good place to put it, but there has been a bit of a change in the machinery regulation has moved from the first part of Annex 1 to the second part. So that means that whereas the machinery, AI and machinery and sort of machinery related products had to comply with a lot of the AI Act requirements plus the harmonised legislation, it's now moved into the second section, which means it will be mostly looking at complying with the regulation related to that particular sector. So moving on to another changes to AI literacy. So this has been softened as a requirement. So previously it was that AI, they had to, providers and deployers had to take measures to ensure AI literacy, and now it's that they have to take measures to support the development of AI literacy in their staff and also other people dealing with and using the systems on their behalf. Again, otherwise it sort of remains unchanged. So you take into account technical knowledge, experience, education, and the context the AI systems are used in. And there is sort of a little addition at the end to saying that it's not, that obligation is not to be understood as requiring providers or deployers to guarantee a specific level of AI literacy in any particular individual. I mean, query, as this has been in place since February, whether this will involve, great changes to how people approach it, but it was a sort of a compromise position, I think, between the original position and what I believe the council was looking for, which was that basically the Commission would be responsible for AI literacy. So it's a bit of a compromise position. Then looking on to small mid-cap companies. Now here we've had some sort of leniencies which applied previously only to micro and small startups and small medium-sized enterprises, which have been extended to small mid-cap companies. Also, they have included sort of what is the definition of a small mid-cap. So now what they do is they cross-refer to another piece of legislation to get that definition. So obviously if that definition does change, then that will affect the AI Act. Currently, we're looking at enterprises with fewer than 750 employees and either an annual turnover up to 150 million euros or up to 129 million on the annual balance sheet. So what are the things that have been simplified? So simplified technical documentation. So some examples of some of the sort of technical documentation that you have to provide, general description of the AI system, sort of contact details, user interface software, and then a more detailed description including sort of testing procedures, human oversight, information monitoring and functioning of the system, detailed description of your risk management system, what are the harmonised standards applied if relevant. So the Commission is going to establish simplified documentation to help small, medium enterprises and small mid-caps to comply with that technical documentation requirement. That's for providers, this is obviously. Penalty-wise, penalties are proportionate. So when we're looking at small mid-caps, so when we've got an either or, sort of an either a X percentage or a monetary maximum, we normally used to saying whichever is the higher, but for the mid-caps it's going to be whichever is the lower, save where we're looking at prohibited systems where it's considered that they should comply with the higher. Then we are looking at quality management system. Again, providers have to have various policies and procedures in place to ensure compliance with sort of various aspects of the legislation. So things like strategy for regulatory compliance and procedures for reporting serious incidents and for procedures for record keeping. So with this simplified system, you'll sort of basically the compliance should be proportionate to the size of the provider's organisations, and it says in particular if the provider's an SME, including a startup, or an SMC. And there are also, I think the Commission is due to produce guidelines and sort of potentially forms, I think, for, again, helping small mid-caps to comply with those requirements. So use of special category data. So in the Digital Omnibus, they have confirmed that you can use special category data, but it must be used exceptionally for bias detection and mitigation. So it can be in relation to both high and non-high risk systems, but it's the exceptional obviously is an important word, and also the standard of use is strict necessity. Apart from those two things, there are further conditions which apply when you're using it. So obviously you would need to check before you're doing it, and there are things, for example, such as don't transfer to, the ensuring that the special category data isn't transferred to third parties, and that are you preventing reuse of the information, and that it's done in a secure manner. So as I said, definitely one to check. So then we're moving on to the high risk guidelines, which are really quite recent, and they do sort of expand on sort of the provisions in the AI Act, but as amended by these Digital Omnibus provisions. So these are currently under consultation at the moment. So it's separated out into three different sections. So we've got first section being general provisions, then the second section relating to Annex 1, and the third section relating to the Annex 3 standalone. So first of all, general provisions, interesting things to note here. There's some interesting information related to sort of the intended use of the system. So if there are multiple uses of the system, you'll need to separate them out to make sure that you review each one to consider whether any of them are high risk. And the guidance does point to the fact that there will be instructions for use, sales material, technical documents, which will set out this kind of intended use of the systems. It also points out that where you have multi-use and general use systems, they will be deemed to include high-risk uses if you're not sort of consistently limiting the application to avoid those high-risk uses, especially where the high-risk use of such system is reasonably foreseeable. So if you're covering a multitude or using a general AI application, then it's definitely you need to be careful in seeing how you can limit the application to not cover high-risk situations. It's a case of substance over form. Just because the provider says high-risk uses are excluded, that's not enough, particularly if you've got sort of promotional material. If you say this, a system which says this can help you sort out your recruitment problems, will sort and pick your candidates, no problem, using AI, then obviously it's conflicting the potential high-risk use there. The other interesting thing that it refers to, and I think something which is always worth keeping in mind, is the risk of a deployer becoming a provider. So under the EU AI Act, if you put your name or your trademark on a high-risk system which is already placed on the market or put in service, or you substantially modify a high-risk system, or you modify the intended purpose of a system so that it becomes a high-risk system, then you'll become a provider of that system rather than merely a deployer. So there are sort of situations in which that can happen, and the Digital Omnibus has actually added a little bit more clarity around the sort of relationship between the original provider and the downstream provider, if you will. So there are requirements that the original provider needs to do specific things to help the original provider to make sure they have the information that they need in order to comply with the provider obligations under the AI Act. And there's also sort of now to be a written agreement in place to set those out. And there is in fact a fine in place for those providers if we're failing to cooperate with the new provider or failing to provide the information that is needed. So moving then on to Annex 1, a couple of things here. The guidance says that the systems which will be considered high risk might be potentially a bit wider than maybe previously been considered, because it specifically calls out there are ways in which you can comply with conformity assessments and different modules. I have to say this is not like fully my area, but I understand that there are different combinations that you might use, and sometimes most of them require a notified body to be involved in the assessment. But there is a module which requires only a sort of an internal assessment. But the guidance is saying that where that self-assessment is it's against specified standards. So because it's against those specified standards, it is a third-party conformity assessment, even though it doesn't strictly speaking involve a third-party notified body. The other interesting bit is the safety component. That's something, sorry, just to recap, remember that Annex 1 systems are systems embedded in products which are intended as a safety component or are the product which is covered by harmonised legislation. So we have some clarity on intended to be used as a safety component. The Digital Omnibus makes it clear now in the definitions that this is where it's either intended as a safety function or where the failure or malfunctioning of that component would endanger health and safety of persons or property. So we've got sort of a bit of clarity that it is very much safety. We're looking at like health, safety, persons and property. It's not just convenience. It's not sort of an AI which optimizes a claims process. It's more like a system to monitor gas pressure so that if it failed, then we might have an explosion, or sort of lane assistance for vehicles where, if it goes wrong, then you've got crashes, you've got potential for harming people. So we, concentrating on that, but also making it clear that it is those two elements. So it's either intended to be used as a safety component or where the failure would result in that risk to life and health and property. So just the other thing that the Digital Omnibus has done really is that in section A, it's tried to lighten the burden a little bit and tried to sort of integrate with sectoral conformity assessments where it's possible. And in section B, obviously there are lighter requirements anyway, but there will be more delegated legislation to follow in relation to those particular sectors. So that's something that people who are interested in that will have to keep an eye on. Then finally, moving on to Annex 3. So Annex 3 is can be changed by legislation. So that list of 8 categories can be changed, but it will need to be changed by legislation. An interesting thing I thought was that there is in the sort of general guidance at the beginning something about natural persons and the definition of natural persons. So it was saying, for example, if you have a small, and that's only relevant to sort of certain of the categories. So for example, the health insurance category is health insurance relating to natural persons. So it's not, so they said, for example, not small business owners. They might be a person, they're not a legal entity, but if you're only sort of considering business data for that creditworthiness, then that's not considering the natural person. Or if you are sort of looking at information relating to a director of a company for whatever reason, that it might be that they're not a natural person because their capacity is in the capacity of the director of the legal entity. So that's just an interesting one for people who are interested in that. Very, very quickly, because I know we are running out of time. The filter, it's got some interesting extra guidance on how to apply those derogations from the high risk. So taking those high risk out of the high risk obligations. So we had the narrow procedural task, which we said doesn't include where you sort of an AI system categorizes information into more or less useful. So, you know, if we're doing a recruitment exercise and we're like, oh, this information is particularly of interest to the recruiter and this not so much, it's more, you know, it's definitely got to be more procedural than that. When we're talking about improving human decisions, this is very clear that it's not a replacement of the human decision. It just has to be improving upon it. So the human decision needs to be the basis still. So detecting decision-making patterns, again, this is like comparing assessments that humans made, but not replacing those assessments. And preparatory task, we shouldn't materially influence a decision with that preparatory task. If it falls under this filter, it's something that doesn't materially influence the outcome of a decision. So that's how you're doing it. Otherwise, it goes through obviously every single of those categories in the standalone systems and very detailed, and I think it would be probably worth a deep dive on one or two of them in another session. But that is me. And I think we are just about and yeah, I think we definitely look at doing some more in-depth stuff.
Yeah, I just want to pick on a couple of things which you said there, Claire. Yeah. Thank you for that. That was really insightful. One was in relation to AI literacy. So even though that has been watered down, if you're using a high-risk system, will have to ensure that people know how to use the system in line with the instructions for use. So you will still have a legal obligation to train people if you're using high-risk systems to make sure they are actually know how they're allowed to use the system in line with those instructions from the provider. And the second point was just, I think it's interesting in relation to the special category data being used for bias detection and bias monitoring, the way that that fits in with GDPR is that that becomes a substantial public interest authorised by union law under Article 9. So that's how you square it with GDPR, because the EU AI Act will be the union law that is permitting the use of that data for that purpose. So just thought it was worthwhile pointing those two bits out.
Definitely. Okay, I think we have gone to time. So if there are, I don't know if there are questions. I can't see if there are. No.
Okay. I don't think there are.
Okay. Well, hopefully that was informative. Thanks very much for coming, and hope to see you later in the year for our next webinar on the 15th of September. But thanks very much, everyone. Thanks. Bye.